Ciao, tutti! Erica Cicero from Cicero Law LLC, here with your Jure Sanguinis moment of the week. This week I want to talk to you about naturalization and how naturalization could make or break your application for blood right citizenship in Italy. First, let me begin with explaining the 1992 reform to citizenship law that the Italian government passed. Before 1992, it didn't matter if a person was born in Italy, was an Italian citizen, and later moved to the United States for naturalization. However, after 1992, the Italian government would only accept blood right citizenship from people whose ancestors did not naturalize in a foreign country before their child was born. This is kind of a complex issue, so let me break it down for you with an example from my own family. My great-great-grandfather, Gaetano, moved from Sicily to the United States in 1910. He started the process of naturalization right away. He filed a declaration of intent, which is basically saying he wanted to become an American citizen. Then, it wasn't accepted for years. As we know, things with the government can take a long time, and that did take a long time. He ended up having a son in 1910, my great-grandfather Nunzio. Nunzio was born before his father was ever naturalized, meaning the declaration of intent and the later petition for naturalization, and then the final step, the naturalization forms, had not come through. All of these many steps over many years had not finished before Nunzio was born. And therefore, Nunzio, born on American soil, was an American citizen because he was born in the United States, but also an Italian citizen because he was born of an Italian father. So that means that his father, if he fathered children after Nunzio, after his declaration of intent and his naturalization process had been accepted, those children would not be Italian nationals. They would only have American citizenship because they would be born solely to an American father, not an Italian and American father. So, what does this mean for your citizenship application? In layman's terms, if your ancestor, your first ancestor, your Italian national ancestor, naturalized before the next person in your unbroken chain was born, you don't qualify. You can't get around this rule like you can with the 1948 rule by petitioning the court. This is a set-in-stone rule. So if your ancestor naturalized before your next ancestor in the chain was born, you're simply not an Italian national born abroad. However, there's a lot of confusion when it comes to naturalization, declarations of intent, petitions for naturalization. And I recommend, if you think that you could qualify, or if you think that your ancestors might have just snuck in the birth of your next ancestor in your chain, before naturalization officially occurred, I recommend contacting my office and we can kind of go through the different paperwork together because there is so much paperwork to this process and it takes so many years that many people mistakenly believe that their ancestor naturalized before they actually did due to the declaration of intent in the petition for naturalization, which both do not mean naturalization actually happened. You need that rubber stamp on the piece of paper to say your ancestor naturalized, and without that, technically, you would qualify. So if you think that you may qualify for Jure Sanguinis and you're interested in inquiring, figuring out more, contact my office. My office information is listed below. If you haven't done so already, please like and subscribe for more weekly content on Jure Sanguinis.